Welcome. Today is day 5 in South Carolina in the trial of Zachary Hughes. Last week, we had a lot of witnesses by the state. They presented their case. And starting today, it is with the defense. Before we ended on Friday, once they muted, the defense went for 3 times to try to get a directed verdict in regards to the harassment charges or the state not meeting their burden on the case. They also went for a mistrial, which all were denied by Judge Patrick Cleburne Fant III. Today should be interesting. I'm glad you joined me. Let's begin. Okay, court is normally on a 30-minute delay, but the delay is a little bit longer this morning because when court started at 9:30 a.m., the judge was hearing arguments from both the state and defense. The state indicated they received briefs from the defense that led them to believe that Hughes's attorneys will suggest that Zachary Hughes was acting in defense of John Mellow's daughter. The state says the argument doesn't hold up because the daughter was not in imminent danger at the time of the murder because she was at school. Hughes's attorneys on the defense of others defense state that this is the case. This is what the case is about. Defense stated if the minor daughter of John Mello had the right to defend herself from this repeated abuse, so did Zachary Hughes have the right to defend her. The defense says the daughter was in imminent danger, referencing the actions taken by deputies and the family court to remove the girl from the home after the evidence of Poster's crimes were found. Judge Fant says he will take a while to consider the arguments. It will be delayed a bit. But this trial is getting very interesting. Defense makes a very interesting argument in regards to defense of others. We knew they were trying to get this evidence in regards to the abuse allegations of John Mellow's daughter. We shall see where the judge goes with it. I wonder if this indicates that the child herself, John Mellow's daughter, will be required to take the stand. If so, my heart is breaking for her to be put in such a situation. I'm not sure if the judge is going to state so, but they're back. And the blog is reporting from inside the courtroom that the judge has denied the defense's motion to include defense of others as their defense. Judge Fonte said since the child was not there and in imminent danger, defense of others is inappropriate, and agrees with the state and denies the defense's motion to proceed with that defense. The blog is also documenting that the judge clearly stated that in this state, the defendant cannot take the law into his own hands. Strong statement from Judge Font. According to the blog from WIS 10 Fox Carolina News, the reporter inside the courtroom says that the defense is still arguing and that Judge Font has taken another break. When the court does decide to go ahead with the trial, we shall see how the defense is going to present their case. They seem to be thwarted in what they intended in the first place, defense of others, stating that Zachary Hughes only was at the Canebrake home to defend the child. The child was in school at the time. The judge stated clearly that he does understand the defense's argument, but it's not South Carolina law. He went to someone else's home that he didn't know and he killed her. The child wasn't at home. This defeats any argument of defense of others. And that's understandable. It does go against South Carolina law. Judge Fant has ruled they cannot bring it in. Well, clearly, going with this type of defense is an admission from Zachary Hughes that he did indeed kill Christina Parcell, and he is responsible for stabbing her 30 times. In defense of the child, the scattering of the rose petals, the moving of the body to stage it, how is all that defense of the child in imminent danger? It doesn't make sense. I understand they were very upset about the allegations against Christina Parcell and the evidence that was found against Bradley Post. This case is wild. It is very emotional. In whatever side you fall on, in defense or not of Zachary Hughes, the law states there is no reason to kill another except self-defense. And even that can only be a mitigating factors in most cases. Okay, well, while we were waiting, the judge came back briefly again. Defense was looking for more clarification from the judge in regards to what Zachary Hughes might be able to say if he took the stand, specifically asking the judge, would he be allowed to say why he did it, why he committed the crime? The judge said no, he would not be allowed to state that he was defending the child. Defense attorney Moorman was shocked and exclaimed, "That's astonishing, Your Honor." The defense attorneys have left with Zachary Hughes to speak with him. The judge is back in his chambers. We did hear that judge is due back and they're bringing in the jury, and we should be starting trial soon. The defense has returned, stating they are ready for their opening statements. They're going to be bringing the jury in now, and we should get started shortly. Either way, it is absolutely going to be quite a day of trial.
Welcome back, ladies and gentlemen. I hope that y'all had a nice rest and break. As I've indicated before, I do need to ask you, has anyone seen anything on news, done any kind of investigation, found out anything about this case? Okay. No one from the jury has indicated they have done such. Okay.
Thank you, Your Honor. May it please the court. Good morning, ladies and gentlemen. Now it's our turn. Mr. Moyer and I have been waiting for a long while to be at this point. I was going to say it's been a week, but it's been longer than a week. It's been years. Our client, Zach Hughes, has been waiting for a lot longer than that. He's been waiting over 3 years, some 3 years and 3 months. As Mr. Moorman told you at the outset of this case, we are honored and privileged to be representing Zach. You're going to hear about Zach in the next day or two. You're going to hear that he's a very gifted and accomplished young man. He is 32 years old now. He was 29 when this happened. He's from a wonderful family. You've probably seen them seated back here in the courtroom throughout this trial so far. You're going to hear a little bit about his life. He was born in California. When he was still a boy, his parents took Zach and his brother, moved him to southwestern Virginia, where they moved into a small farm, and then they took on 5 orphan children who lived there with them. And you can hear that Zach was homeschooled. He learned the value of hard work and discipline as he grew up around the family farm. He helped his young siblings. His family moved to Greenville when Zach was a teenager. In Greenville, he finished high school, being homeschooled still. And you'll hear that his hard work and his discipline paid off, and he was accepted into a very fine college with scholarships. He went on where he studied music, and he won piano competitions. His emphasis was on piano performance. As an adult, Zach has had an accomplished career performing classical music and even recording classical music. So this is the time now for our case and for Zach to testify. But understand, ladies and gentlemen, that we have no obligation under the law or the Constitution to be doing this. This case actually could be over when the state rested. The state has the burden of proof of proving this case in every element of every charge beyond a reasonable doubt. We would not have to put up anybody. Zach wouldn't have to testify, wouldn't have to put up any witnesses. In fact, if Zach were not here, His Honor would instruct you that you couldn't use that against him. But we are going to do so. And Zach is going to testify because Zach has been waiting for this opportunity to tell a group of people like you what really happened, which is that he took the life of Christina Parcell. And crucially, he's been waiting and wanting to tell you why. Now, the why to a case like this is very important because it goes to the heart of the matter, and that is malice. Okay, malice is what makes a homicide a murder. And we heard from that from the prosecution's opening, as you recall. The prosecution said that Zach was mad. They said he had an angry heart, that he wanted to inject himself into this custody dispute of somebody he knew. But that's not why it happened. And that is not what you were going to hear about why this happened. Now, as we turn to our case now, it's important to realize that we could have handled this case extremely differently, okay? We could have attacked the sufficiency of the state's case. We could have brought in an expert to talk about the DNA, okay? We didn't do that. We could have challenged the identification evidence. And I want you to consider the professional from law enforcement, from the state law enforcement division, who testified about the enhancement that they did on the videos and the photographs, and how they were able to use this fancy technology to enhance and to account for the differences between sunlight and shadow and the distance. And after all of that, and after all of the technical work that was done, the conclusion was that the guy on the bicycle was 6'5", a big guy like him. Well, as you probably noticed, and as you will see, Zach is shorter than I am. On a good day, I'm 10 foot. I'm 6 foot, 5 foot 10 inches. Okay, he's shorter than I am. Consider the other professional. There's one who spent a great deal of time looking at the the enhancement of the person on the bicycle. And after all that time, what was that conclusion? That this person had a beard, it has to be a man. And they enlarged it and they used, again, all of that technical information to take a look at it. This guy had a beard. This is before they had any suspects. Well, what do we know about Zach and what we learned about Zach? He was clean shaven. We know that from a couple of days prior, and we know that from a couple of days after. We could have attacked that. We could have attacked the identification from the neighbor. As you remember, a neighbor, after 3 years, came into court. And all of a sudden, after 3 years, was able to identify the man whose picture had been on television for the past 3 years. Had never told anybody even that she could identify somebody. And this was somewhere between 8 and 8:15 in the morning. And what you're going to find, ladies and gentlemen, is that couldn't have happened because the person on that bicycle was not even in that neighborhood for at least an hour to an hour and 15 minutes later. But we didn't attack that. We could have done that, and we could have made mountains of objections throughout this trial. And as you heard, we made very few, and we did not do it. And why is that? Because Zach wants to take the stand and tell you what happened. Now, the prosecution has told you that they will prove this malice in this case by showing you that Zach was mad, that he was angry. And malice is a key part of this case because malice is the very essence of the definition of murder. Okay, so what is murder? Murder is the killing of somebody with malice aforethought. And what is malice? The prosecution told you it's anger, that is madness, and that is a component of it. The definition, though, it is the killing of a person without just cause or excuse. The intentional doing of a wrongful act without just cause or excuse. And I want you to think about those words, that definition, as you listen to the testimony that you're about to hear in this case. The why to the homicide is very important because it gives insight into the person's heart. In this case, you were going to hear that the why was not jealousy or greed or a crime of passion or some other emotion. You're going to hear that Zach did not act like an angry heart like the prosecutor conjectured. You're going to hear that this was not done for money or any other personal gain or benefit, not to help out any kind of friend. You're going to hear that this was done for a just cause. And that's not malice, and that's not murder. Thank you.
Hey, Councilor Burke.
The judge has called the attorneys to the bench. And I suspect we are going to have another delay. So despite the judge saying that if Zachary Hughes testifies, he cannot say why he did it by mentioning the child or that she was in immediate danger, it does appear that the defense just did say in opening statements that he would be. I believe that is what the discussion is about. We'll see. I do suspect another delay. At this point, they're probably going to take lunch to sort it out.
The witness is just making a phone call. He'll be right back.
Ladies and gentlemen, I'm going to send you back to the jury room for a moment, and then I will be back with you. I really want to also thank you just for your patience. We've had a lot of legal issues that I've had to take up with the attorneys, okay? So I will be back with you shortly.
It does appear that Judge has his serious face on right now. There's a lot going on.
Okay, welcome back. I would have kept you in here if I had knew I was going to get my answer so quickly. It is 12 o'clock. I'm going to ask that y'all return at 1:30. We're going to take a break, enjoy your lunch, and then we will pick up at that point. Again, I remind you of everything that I've punished you about before, and do not begin any deliberations or discussions about this case. Okay, we'll see you back at 1:30. Thank you.
Well, there we go. We are back just to announce that we're out for lunch. We'll resume after 1:30. We'll see if this trial actually gets going for today. It looks like we will be starting the feed after the lunch break shortly. Law and crime seems to be coming up in a couple of the others, so hopefully they will be bringing the jury in and we will proceed with the trial for today. Remember, it's the defense's turn now. We heard their opening statement earlier, amidst all of the breaks in between. We do have reporting on the blog that they have called in their first witness, and testimony did begin about 30 minutes ago. So we should have the feed shortly. The first witness is scheduled to be Investigator Bevell, from the state's case. It appears to be set up as an impeachment witness. Apparently, they're going to go over his testimony about something. So I'm very curious to see what happens here.
Hey, welcome back. Again, I ask, has anyone heard, done any research or anything concerning this from any media outlet? Vote would note for the record, jury indicates absolutely not. Vince?
May it please the court, defense would call Investigator Dan Bevell.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record.
Daniel Bevell.
Investigator Bevell, you were called in the state's case in chief. Do you remember that?
Yes, sir.
And my understanding is it correct that you began working for the sheriff's office, Greenville County Sheriff's Office, roughly in 2012? Is that correct?
That's correct.
And you got a bachelor's degree from Troy University. Is that correct?
Yes, sir.
You testified about this previously, but briefly tell this jury what units you have served in the sheriff's office.
I started in patrol from 2012 to 2017. That's your standard uniform patrol deputies answering 911 calls, any kind of call for service. After that, I went to specialized investigations from 2017 on to, and there I went to the Crimes Against Children unit from 2017 to 2019. That's any kind of child abuse, child neglect, child sex crimes. Then after that, 2019 to 2023, I went to the Internet Crimes Against Children unit. That's any kind of child exploitation.
Investigator Bevell, you talked about your time in the Crimes Against Children unit. When you're in a specific unit within the sheriff's office, do you receive specialized training associated with that type of unit?
Yes, sir.
Right. And so when you were on the road in uniform patrol, did you receive specialized training related to that?
Yes, sir.
And when you were in the unit of the Crimes Against Children, did you receive specialized training in that discipline?
Yes, sir.
And let me show you. Let me show you Defense Exhibit 65. Just take a look at this for identification only.
Yes, sir.
Investigator Bevell, for example, that is the report you drafted for the purpose of the harassment investigation. Is that correct?
It is, sir.
And so this is of the kind of report you would draft depending on what investigation you were conducting or what tasks you were performing with the sheriff's office.
That's correct.
As an investigator, are you familiar with a phrase called the lead investigator?
Yes, sir.
And ultimately, the lead investigator is just that the investigator on a case who is ultimately responsible for the investigation. Is that correct?
Yes, sir.
And in this case, Investigator Sparkman would be deemed or likely be the lead investigator. Is that correct?
That's correct.
Were you also the lead investigator in another case in connection with this case? Let me ask it a different way. On October the 19th, 2021, did you become the lead investigator in another case?
Objection. State your objection.
Objection, this is going to fall under your previous ruling.
Okay. I will sustain the objection.
Okay. Your Honor, due to Your Honor's previous order with the restriction, I'm going to move on, and I'm going to move on. Investigator Bevell, you testified, as you said, in the state's case in chief, and that was just last week, wasn't it?
Yes, sir.
And I would imagine you're still familiar with your testimony in the state's case in chief.
Yes, sir.
And I want to talk to you about that testimony. And specifically, I want to refer to a specific portion of it. Do you remember during your direct examination, you testified about mailers and the contents of mailers that you had been provided in the early summer and through the summer of 2021? Do you remember that testimony?
I believe so. Are you referring to the mailers as what I was given by Postman Parcell?
Yes.
Yes, sir. Yes, sir.
And you testified that those mailers had nude photographs of Christina Parcell in those mailers. Is that correct? Remember that?
Yes, sir.
And I've got a transcript. I want to ask you specifically about this exchange. Do you remember being asked by Mr. Wilkins, when you first got these photos, let me back up. Do you remember testifying about the fact there was a website listed on the photographs? Do you remember testifying to that?
Yes, sir.
And do you remember Mr. Wilkins asking you about questions about different fonts and different placement? Remember that?
Yes, sir.
Do you remember Mr. Wilkins asking you this question? Now, when you first got these photos, did you attempt to try to find the website on there? Do you remember that question?
Yes, sir.
And you testified, yes, sir. You remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, how'd you do that? And you testified, I just typed the address into one of our computers in the office. Do you remember that?
Yes, sir.
And do you remember Mr. Wilkins asking you, and what did you find? And you testified that the website no longer worked. Do you remember that?
Yes, sir.
And then do you remember Mr. Wilkins asking you, so you put belladondigiorno.com escort site and put it in your computer, and you responded, yes, sir. Do you remember that?
I believe so. Yes, sir.
And he asked you what happened, and you said, it just redirected me to another escort website. Do you remember that?
Yes, sir.
And then then he asked you, were any of those photos on that escort site? And remember, you testified no.
John, I'm sorry, I got an objection. Can I?
I'm almost done. One more line.
I'm going to let him ask this question.
You remember Mr. Wilkins asked you, were any of those photos on that escort site? And you responded, no, sir. Do you remember that?
Yes, sir.
And then just one more. Do you remember he asked you, was any pictures or were any pictures of Christina Parcell on any of those websites that you found? And you testified, no, sir. Do you remember that?
Yes, sir.
Isn't it true that in the harassment report that I just showed you, Defense Exhibit
John, I've got another objection I need to make. I need to just put it on the record.
Yeah, this is,
I'm sorry.
Okay, an objection. I'm trying to figure out where he's going with this. I mean, if the pictures were not on the website when he went to look, what can they do? Or maybe he's trying to enter evidence of the pictures existing. Perhaps, but I mean, if the investigator looked at the time and they weren't there, how are they going to correlate that? You can hear in the defense attorney's voice that he's being very careful about how he is presenting this and how he is questioning the witness. The judge has made it very clear he wants no shenanigans in regards to the minor child in the allegations against Christina Parcell that are to date not being validated, nor was she charged with anything. She's the victim in this case. And I do realize that Zachary Hughes is entitled to the best defense that he can get. But re-victimizing a victim is not really a good look. And saying that they were defending the child and this is the reason for the murder, well, I'm sure that it will make people think and take pause. It is a horrible event. But does it actually justify murder? Is it actually a reason to let him get away with it? I don't think so. And they're admitting he did it. He needs to pay the consequences. If anything, this will just end up as mitigating factors in the end to sentencing, in my humble opinion.
So again, let's pick up where we left off. I had reminded you of your testimony from last week, wherein you were asked the following about typing in this website. And you're asked what happened, and you testified it just redirected me to another escort website. Then you were asked, were any of those photos on that escort website? And you testified, no, sir. And then you were asked, which you previously testified to, were any of the pictures of Christina Parcell on any of those websites that you found? No, sir. You remember that testimony?
Yes, sir.
Isn't she in your report on the harassment allegations?
Your Honor, I'm reading.
Your Honor, he's an adverse witness, 611C. He testified for the state. He's a member of the Greenville County Sheriff's Office. I have every single right to lead him pursuant to 611C.
Your Honor, he's their witness. They call him. In a direct examination.
Witness, so I'm going to sustain the objection.
All right. Well, I'm going to show you Defense Exhibit 65 again. Look at this bottom paragraph. Would you please read what I have bracketed to the jury?
Yes, sir. I photographed the 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One contained black and white nude images of Parcell with the address checklist. The images have a web address of http://belladonna.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were not in color.
So is it true, based on this report, that you were redirected to other websites that had the same images that were in those envelopes? Isn't that correct?
No, sir.
Okay. Isn't that what you said in your report?
That's poorly worded on my part, but I meant the other envelopes. Same images were not in color.
What are you saying you meant?
The images that were in the other envelopes, not another website.
So didn't you say that you found these on the internet? Isn't that what you said in your report?
No, sir.
Tell me again what you said. Yeah, please read it again for the jury. Read it again.
Okay. It's okay if I go to the relevant part instead of
Yeah, I've got a bracket there.
Okay. Photographed 6 envelopes and the contents of the open ones. The open ones were addressed to Brad Post. One envelope, or it just says one contained black and white nude images of Parcell with the address checklist. The images have the web address of http://belladonna.escort-site.com. I checked this web address and it was not valid. It redirected me to another escort site under a different URL. The other contained several of the same images, but were in color. Now, like I explained, it's poor wording on my part, but I was referring to the other envelopes contained several of the same images, but they were in color. I wasn't referring to another website.
And in your report, you don't distinguish between envelopes and websites, do you?
Like I said, it was just poor wording, but I was referring to just other envelopes had the same images, just in color.
And isn't it true that it is very possible that those images could have been online and just taken down at the time you tried to look at them? Isn't that true?
In another website, is that what you're referring?
Yes.
Yes, sir.
One second. Your Honor, those are all the questions I would ask Investigator Bevell in this context. Yeah, I don't have anything further on the examination.
You want me to please the court briefly? Did you ever find naked photos of Christina Parcell on the internet when you checked?
No, sir.
It's because it didn't exist that you could find.
Not that I could find.
No further questions.
Nothing else, Your Honor. Okay. Your Honor, there is, Your Honor, pursuant to your previous ruling, I would like to present some information in the absence of the jury.
According to the Wiz 10 blog from Fox Carolina News, apparently the defense is proffering to the judge witnesses that they want to bring forward because it is all involving the pictures of Christina Parcell. It is quite the contentious case. I realize how upsetting it is to understand that there was CP involved, in that Bradley Post is facing charges upon this, and there are allegations against Christina Parcell too, by the child's father, John Mello, who has very clearly, with Zachary Hughes, done quite an exposure campaign of harassment against her with pictures, personal pictures of her that look to be taken by John Mello, previous, inciting that she may be on a website, which they couldn't find correlation for. No other evidence to support it. And I do remember the family law attorney who testified, Vanessa Cormiolo, who is also on the defense's list and may testify today. I am uncertain at this time if the judge is going to allow it. But she said that they did investigate these accusations made by Mello several times. Now, they couldn't find anything to back it up. Now, they say that the child was at risk. Well, they did what they could, and they removed the child, but they never found anything to charge Christina at the time. I understand that everybody's upset about that angle of the case, but this isn't a case against Christina Parcell for child pornography. This trial is in regards to her murder. Zachary Hughes and his defense team are trying to twist it into a case against Christina Parcell for abuse of her child. She's not here to defend herself or to face the charges. Whether it is true or not, it would have needed to go through the process, legal proceedings the same way that Zachary Hughes has a right to defend himself against the charges of murder, which he clearly is stating he did, according to his defense attorney's opening statement. Christina Parcell has the right too. Well, she's not here. And we need to stay focused on what this trial is about. And I understand the defense is trying to give everything they can to the jury to try to nullify a conviction. The thought of a child being violated, well, it incites people to crazy thoughts. It is totally horrific and irreprehensible and unjustifiable. And I get that. It also can inflame a jury. And so before we say that the judge is being biased, a lot of comments that I see in the blogs, on Twitter, in several places that I'm following right now in regards to this case, the judge is doing everything he can to keep this trial about the murder and not to unfairly cast blame on a victim not here to defend herself. There are laws that protect victims in cases like this, and the judge has to follow those rules and those laws. It doesn't mean that he supports anything that may have been done to a child. So just stop with all of that. It looks like they're coming back in for a moment. Let's see what's going on.
Okay, ladies and gentlemen, today has been a little bit of an unusual day just because there's been a lot of legal issues that I've had to go over with counsel, and I am grateful for your patience. As I've stated on numerous occasions, I thank you all for your service on behalf of the state of South Carolina. I thank you in Greenville County. I'm going to allow y'all to break for the day. I'm going to ask that you come back at 9:30 in the morning. Consistent with my admonition to you all. Again, you are prohibited from watching any type of TV coverage of this trial. Do not do any research on anyone involved in this case. You're not to look at any social media. It's important to this trial, justice and fairness to the defendant and the state, that you only consider the evidence that comes in through this courtroom, and you're not to discuss this case among yourselves. Begin deliberating until I tell you to do so. And lastly, if anyone approaches you to talk to you or ask you anything about this case, you need to immediately let me know, okay? I will see y'all at 9:30 in the morning. Thank you again.
Well, there we have it. Jury dismissed for the day. Trial to resume at 9:30 in the morning with the jury. Well, it does appear that according to the blog from the reporters who are inside the courtroom, that the defense is going to continue with the judge to proffer witness testimony that they plan on presenting. So I will update as it goes. I'll give you a summary in a few. Okay, court has been dismissed for the day. Now, we know earlier the jury was sent home. However, the judge did actually allow the defense to proffer the rest of their defense witnesses for him in order to stay within the guidelines of what he has set forth and how much of the CT allegations are allowed to come in. And basically, all throughout the day, the defense had already proffered in the morning the testimony of the owner of the Outman Cigar Bar, and they were going to bring forth that Bradley Post had a locker there, and in that locker was discovered some hard drives and some USBs to which an investigator also was brought in to collect those devices. And on those devices were found thousands of images of CP. The defense went into great detail on the images and also in regard that several of them included Christina Parcell and her daughter. Now, the judge reminded them again that they don't have to go into such great detail in regards to the CP. And they tried to pull it back a little bit, but they said they were going to bring in their own forensic digital expert to quantify the images and what they are and how many there were. You see, the judge is leaving for the day. He picked perfect timing as I'm making my closing, but they're out. There's going to be no more testimony for today. The defense also proffered for the judge that they would be bringing forth Vanessa Cormillo again and actually discuss the case for the child in regards to protective services, and also that she had stated that Bradley Post had a creep factor, and to go into detail in regards to that. The rest of the afternoon was dedicated to testimony of a Dr. David Corwin, who is a psychiatrist who specializes in child sexual abuse, who talked about the effects of child abuse, of sexual child abuse specifically in long term on the development of a child, and the effects that it can have long term in the future, some of the side effects, etc. All of the adverse outcomes. The state did cross-examine Dr. Corwin also. And then they actually just concluded for the day. So we shall see how that's going to progress. Before they dismissed for the day, however, Zachary Hughes did tell Judge Fant that he is going to testify, that he has decided to testify. And on that, court is finished for the day. Court resumes tomorrow at 9:30 a.m. with the jury present as instructed. In the meantime, if you like what you heard, even if you didn't, leave me a comment and tell me what you'd like to see, what I could do better, what other cases you'd like to follow. Ask any questions you'd like that I could possibly get answers for you, and leave any comments in regards to the trial, because this is really an interesting one. I look forward to hearing from you. Please like, share, and subscribe. And on that, everyone have a great night.